Welcome to our detailed summary of the court ruling involving Uber and the Chief Commissioner. This case revolves around Uber's objection to payroll tax assessments, totaling over $81 million for the years 2015 to 2020. Ultimately, it was held that whilst the contracts between Uber and the drivers were relevant contracts for payroll tax purposes, the amounts paid by Uber to the drivers were not for or in relation to the performance of work. Let's dive into this a little deeper. Uber operates by connecting riders with drivers through its apps, being the driver app, used by drivers, and the rider app, used by riders, facilitating transportation services. The apps are platforms which enable drivers and riders to connect, which in turn enables drivers to be available to provide transport to riders. Uber had three key contentions. First, Uber contended that its contracts with drivers were not relevant because transportation services were provided by drivers to riders and not to Uber. Second, in the event there was a relevant contract, an exemption from payroll tax applied. In this regard, they submitted first that the work was ancillary to the use of goods. Second, that the services were provided for less than 90 days. And third, that the drivers who are also registered taxis ordinarily perform services of that kind to the public. Finally, Uber contended that amounts paid by it to drivers were not paid for or in relation to the performance of work under that contract, and therefore are not taken to be wages paid or payable. In considering the complexity of the relevant contract provisions contained in the Payroll Tax Act, the judge noted that the words, "the designated person has supplied to the designated person the services of persons," are, when literally construed, capable of meaning that the designated person has supplied services to itself, an absurdity. In assessing the case, it was determined that a trichotomy analysis be adopted, focusing on three distinct services. These were driving the vehicles, rating the driver and passenger, and referring other drivers. The court found that each the driving, rating, and referring were in fact services, and further that these services were supplied to Uber under a contract. Specifically, the contracts give drivers and partners the right, if and when they drive, to use the driver app. They have the right to use the driver app even if they choose not to drive. The right to use it, and all the entitlements and benefits stemming from its use, including the opportunity to drive or to decline to drive for gain, have their source in the contracts. Accordingly, the court concluded that the contracts were in fact relevant contracts for payroll tax purposes. Following the establishment of a relevant contract, the court then considered the relevant contract exemptions. The first exemption put forward was that the ancillary exclusion should apply on the basis that the services are supplemental to the use of goods owned by the service provider, like a vehicle. The court held that with respect to driving and service, there is no room for separating the two into elements in order for one to be capable of being ancillary to the other. The court did consider, however, there was scope to treat the rating of a rider as a service ancillary to the use of that vehicle. Uber put forward a unique argument around the 90-day exemption, contending that it should be viewed in light of the Passenger Vehicle Transportation Award, and that a day for the 90-day exemption should be based on working 7.6 hours. The judge noted that such an argument was untenable and that no foundation for such a position could be found within the Act. Finally, the to the public generally exclusion was also examined. Uber argued that some drivers held taxi licenses but failed to prove these drivers ordinarily performed such services to the public. The final consideration for the court was whether amounts paid or payable by Uber should be taken to be wages paid or payable under Section 35(1). Section 35(1) requires identification of a connection between the payments made by Uber, the subject of the assessments, and work done by drivers under the contracts, so as to make the payments for or in relation to that work. The court noted that the overall intention behind Division 7 is to capture several means of disguising the employer-employee relationship by contractual arrangements, which had been increasingly resorted to by persons seeking to defeat the objects of the Act. In this regard, it was noted that the characterization of the payments made by Uber must proceed by reference to the contracts, which reflect and govern the legal relationship between the contracting parties, and by reference to the rights and obligations to which the contracts give rise. The quoted clauses of the contracts provide expressly that riders' payments are considered the same as payment made directly by the rider to the driver or partner. What the rider pays the driver is for or in relation to the work done by the driver. What Uber pays the driver is in relation to the payment Uber has received, not in relation to the work itself. It was on this basis that the court concluded that amounts paid or payable by Uber to the drivers or partners were not for or in relation to the performance of work, and are not taken to be wages paid or payable. It is evident that many of our payroll tax laws were drafted long before services like Uber existed. So in this regard, we support the practical application and updated precedent, and we expect this case will have a far-reaching impact across a number of industries. As always, please feel free to connect with your local RSM contact, being myself and Peter in Melbourne, Gina and Neve in Perth, and Jason in Sydney.